If you are an international or returning student trying to find a bed in Ireland for the 2026 academic year, you already know how stressful the search is. Just walking through the major university campuses, you can see the pressure of thousands of people looking for the exact same limited accommodations. This graph shows the math behind the panic. By February 2026, the entire country had fewer than 1,800 rental listings available. That is a 22% drop from the previous year. To address this scarcity, the government enacted major legislative reforms on March 1, 2026. They wiped out the old rent pressure zones and introduced a strict national 2% annual rent cap, along with new 6-year minimum tenancy cycles. This forces you into a difficult trade-off. Do you wait it out for a highly protected standard lease, or do you accept a readily available but precarious digs arrangement just to secure a roof over your head? Surviving this market means treating your housing contract as a legal battleground. How you are classified on paper dictates your exact legal reality. First, look at the standard tenancy. This applies when your landlord does not live on the property with you. Under this arrangement, you are fully covered by the Residential Tenancies Act and regulated by the RTB. Then there is the licensee arrangement, commonly called digs. This happens when you rent a room in an owner-occupied home. This chart details the legal trade-offs. As a licensee, you forfeit the 2% rent cap, have zero RTB access, and no statutory notice periods. The financial risk escalates. Without RTB enforcement, deposit disputes go through the small claims court, costing additional time and fees. Digs do have an upside. They offer much faster accessibility and often feature a lower baseline cost, making them tempting if you are desperate or on a strict budget. But while a licensee agreement solves immediate homelessness, it legally exposes you to sudden evictions and unlimited rent hikes at any moment. If you manage to secure a standard tenancy, your primary financial shield is the rent cap. From March 1, 2026, landlords can legally raise rent by no more than 2% per year, or the rate of CPI inflation, whichever is lower. To implement that increase, landlords must follow strict rules. They must provide at least 90 days written notice before any extra charge takes effect. Here is the critical March 2026 loophole. That rent increase notice is legally invalid if they fail to send a copy to the RTB simultaneously. You should always proactively verify any proposed increase by plugging the numbers into the official RTB rent calculator tool online. Take the real-life example of Priya, a student at the University of Limerick. Her landlord tried to raise her rent from €1,100 to €1,250. She checked the RTB printout, proved the actual legal maximum was just €1,122, and forced him to back down. Confronting her landlord with that paperwork saved Priya €128 a month, which adds up to a massive €1,536 over a single year. The 2% cap is not an automatic force field. You have to actively enforce it by verifying the paperwork and holding your landlord to the letter of the law. When it comes to moving in, the statutory limit on deposits is rigid. A landlord can legally demand exactly 1 month's rent up front and nothing more. When you eventually leave, they can only deduct money for 3 specific reasons: rent arrears, unpaid bills you are responsible for, or damage that goes beyond normal wear and tear. Normal wear and tear includes minor scuffs, carpet wear, and small wall marks. Landlords cannot legally withhold your funds for these standard signs of living. The 2026 reforms also introduced tenancies of minimum duration. Any new standard tenancy signed after March 1st now runs on a full 6-year cycle. This places a major restriction on large landlords, meaning corporate entities or those with 4 or more tenancies. They cannot legally end your lease mid-cycle just to sell or refurbish the property. This chart shows exactly how your eviction notice rights escalate. If you stay under 6 months, the landlord only has to give 90 days notice. But once you pass that 6-month threshold, your required notice jumps to at least 152 days. Surviving past that 6-month mark legally fortifies your position, severely restricting your landlord's power to force you out on short notice. This flowchart outlines the clear dispute escalation paths available to standard tenants. You can opt for free telephone mediation, resolved in a few weeks, or a formal adjudication for a €15 online fee, taking 4 to 8 weeks. Spending the €15 for adjudication yields a legally binding determination order, but winning that order requires robust, time-stamped evidence. That is why your absolute most crucial habit starts on day 1. Conduct a narrated video walkthrough noting every piece of pre-existing damage, and email it to your landlord immediately. Plan your next move. Treat digs as a temporary stopgap. Never pay a massive deposit, as the RTB cannot recover it. For anyone staying over a year, secure a standard tenancy. The 6-year security and rent caps protect your budget long-term. Ireland's rental laws offer strong protection, but only for active, documented participants. Trace all rent payments via bank transfer and verify your legal registration on the RTB website immediately to protect your stay.